Good morning, Madam President. Good morning to my colleagues on this side and my colleagues on the opposition benches. Madam President, I rise to commence the debate and have read for a second time the bill shortly entitled the Nevis Business Corporation Amendment Bill 2023. I believe it was on the 6th of July this year that bill would have had its first reading. And we would have adjourned then to allow for public scrutiny and consultation. And we are now back in the hope that we could have the debate today, have the bill read a second time, debated, read, and hopefully with the support of the House passed. Madam President, the bill that is before us, the Nevis Business Corporation Amendment Bill 2023, seeks to advance the financial services industry on the island of Nevis. And the public would be aware that we have come from time to time to undertake amendments to various bits of legislation. Indeed, we have in the past repealed and replaced entire ordinances in an effort to ensure that the financial services industry on Nevis remains current, remains modern, and remains competitive. And the public may ask from time to time, well, why do you spend attention and so much time and give so much attention to the financial services industry? And the answer is simple, that it is a significant part of the economy of the island of Nevis. It not only generates direct revenue in terms of registration fees, renewal fees, and taxes to the Nevis Island administration, but it also generates good quality jobs. It generates rental income for many who own premises around Charlestown, the capital, and elsewhere. And it also generates the activity for the island in terms of business. And so we feel, Madam President, this financial services industry, which started way back in 1984 and was expanded dramatically since 1996, that this industry deserves our attention. And if the public is wondering what I mean when I say it started in 1984, the Nevis Business Corporation Ordinance was actually passed in 1984. And that signaled the start of the financial services industry for the island of Nevis. However, the government of the day, the NRP-led government, saw it fit to give an exclusive arrangement to one company in 1984. I don't say that by way of criticism. I say that because that was the fact. And Morningstar Holdings obtained a monopoly on financial services from 1984 for 10 years until 1994, when that monopoly came to an end. I believe the thinking in 1984 by the government then was that this was a new industry and they wanted a partner that they could trust and rely on. And there was, because when we talk about financial services, a lot of people become fearful. We start to hear about money laundering, terrorist financing, and of course the dreaded blacklisting. And I am sure, no doubt, that the government of the day felt that this was a safe way to go. And that is the decision that they took. We can look back with the benefit of hindsight and say that hindsight, they say, your vision now is 2020 because you now have the benefit of seeing what would have happened. And we can question whether or not that was the right decision, but that was the decision nevertheless. And so the industry would not have started to expand considerably until 1994, when that monopoly ended and when we then saw new products being introduced. Nevis Limited Liability Company Ordinance, I believe that's the LLC legislation that came, the banking legislation that came, mutual funds legislation, insurance legislation, trusts that came, Nevis International Exempt Trust Ordinance, which has generated considerable business here on the island, All of those came after, but not only did new legislation come after the monopoly ended, but new businesses opened their doors. And so we did not any longer have just Morningstar Holdings. And a lot of trust companies opened their doors, and that generated new activity. A lot of banks were registered that generated new employment. And so we saw an exponential expansion. I remind people all the time that the British Virgin Islands, which has become a powerhouse in the financial services industry in the world, a global powerhouse, that the British Virgin Islands would have had a start to the industry at around the same time as Nevis, back in 1984. But they, unlike Nevis, did not grant any monopoly to any one entity. And so what we started to do in 1994, they had done from the inception. And the BVI today is, as I said, a global powerhouse. We are not quite there yet, Madam President, but we are working our way towards that. And I'm very pleased with the progress that is being made. In Nevis, the growth has been steady. It has been incremental, but there has been growth. In fact, I'm proud to say, as I lead the debate on this bill, that the number of registrations as of July 2022, and I'm talking about new registrations, across all financial services entities was 1,044. Put differently, so that I'm clear, the registrations from January to July 2022 was 1,044. The registrations from January to July 2023 stand at 2,061. So there has been an increase between January to July 2022 when compared to January to July 2023 of some 1,017 more entities registered, or some 97.4% increase in the number of entities registered. Of course, Madam President, new entities are being registered, and our staff, our regulations department, our staff at the registry will, from time to time, strike off companies from the register. So some are coming on, and some are also leaving because some are being struck off for a variety of reasons. And so that has an impact on the revenue that comes in from renewals. But I'm advised that the revenue that we would have earned as of July 2022 for that year, January to July 2022, was $7.1 million. The revenue earned thus far this year for the same period, January to July 2023, is $8.1 million. So we have seen, Madam President, is that the island of Nevis, in relation to this particular sector, is moving in the right direction. I have said to the officials at the registry that I see no reason why we should not be able to double our registrations and double our revenue for each year going forward over the next 5 years. And I've said that because we have not only embarked on a process of refining our legislation and ensuring that we remain on the cutting edge, but also investing in greater technology and also investing in marketing. And we have partnering with the sector in a significant way to undertake marketing efforts across the world for the financial services sector here. There are many, Madam President, who have announced the death of this sector from time to time. As they say, rumors of its death have been greatly exaggerated, because we have, notwithstanding the negativity surrounded the sector and the press that has been self-serving in many respects, generated by some who are quick to cast aspersions on us as a region while ignoring what is happening in their own countries. We have persevered, we have pressed on, and we have met our international obligations in a direct way by engaging in dialogue with the agencies that monitor the sector and ensuring that we remain on the cutting edge and that, most importantly, we remain compliant. And that is the backdrop to why we have come today. The bill today is not particularly remarkable. It seeks to do a few things, and I will go through the sections, Madam President. It seeks to create and make some amendments that have been proposed based on changes in the general industry standards regionally and internationally, and the absolute need for the industry here in Nevis to remain updated as well as to remain competitive. I would want to inform this House that changes that are proposed are always discussed with the industry. I say discuss because we don't always have unanimity. The industry does not always agree with everything, but we always engage with the industry. And so no one can say that they're taken by surprise when we come to this House on these matters. In fact, time and time again, Madam President, we have held off coming to the House when the industry leaders have said that they want an opportunity to opine or that they don't agree. And so our approach to legislation has been consultative, and we have engaged in ongoing dialogue with the industry. And so these changes are changes that have been discussed and that are now here as a consequence of changes in the international landscape, but also changes that will ensure our competitiveness is maintained. At Section 2, we have amended by deleting the definition of authorized custodian. As that appears in that section, the definition has been removed based on amendments to have all references in the ordinance related to bearer shares removed. I want to pause there. There has been an ongoing debate, Madam President, as to whether countries, jurisdictions should allow bearer shares. Bearer shares, so that the public understands. There are many lawyers in the room, so I know they would understand already. But for those who may not be lawyers or may not have had contact with the industry, and generally for the public, that bearer shares basically say that the shares belong to the bearer of those shares. And so there is not necessarily anybody's name on that share certificate. That share certificate doesn't say that it belongs to Mark Brantley, for example. It will merely say that it belongs to the bearer. Now, it is an excellent instrument in terms of ease of doing business. It is also potentially a dangerous instrument because unlike registered shares, which have a name attached to them and move in a particular way, where, for example, there has to be a record kept of that share moving from person A to person B. Bearer shares are, as I said, owned by the bearer. And so it means that a bearer share can simply be delivered from person A to person B. And it renders it difficult to monitor from a regulatory point of view. Now, some years ago, Nevis took the position that we would not abolish bearer shares. Rather, we would seek to immobilize them. And the position that was taken then was that while we continued to allow bearer shares, those bearer shares had to be in the possession of an authorized custodian. And that way, we felt it would prevent the free transfer of the ownership of a company, as was hitherto the case. We have now, Upon reflection and upon changes being made in the landscape, and as the industry evolves, come to the view that it is now time to outlaw bearer shares altogether and to remove the provisions in our law that allow for bearer shares. And so the authorized custodian, which was a creature created because we wanted to immobilize the bearer shares in the hands of a custodian, that creature is no longer necessary because the authorized custodian was authorized by the minister to act as a custodian for bearer shares only. So Section 2 has been amended to remove the definition of authorized custodian because, for the reasons that I have just set out, Madam President, we no longer will allow bearer shares in Nevis. We have added a new definition in the definition section, Section 2, for electronic signature. Madam President, in this regard, I will admit Nevis is a bit late to the party because other jurisdictions have long had the ability to allow documents to be filed with an electronic signature. And so what we're doing here is playing catch-up in our legislation. Again, so the House and the public understands, it used to be the position that the registry could only accept documents that had been physically signed. And we got the complaint from the service providers saying, in this modern age, when other people are filing electronically and using electronic signatures, why is Nevis still in the Stone Age, requiring people to sign handwritten signatures? And so we have now responded to that, Madam President, by introducing the provisions relevant to the electronic signature. Incidentally, as I looked at the explanatory memorandum prepared by the legal staff for this bit of legislation, I came across a term, and I'm not somebody who is ever too big to admit that I learned something. I learn something every day. And it said that our legislation now will allow electronic signatures. They will also allow something called a wet signature. You know what a wet signature is? I had never heard the term before. But apparently a wet signature is when you sign with pen and ink. So I think for those in here who knew it, I did not know it. So I went and did a quick check to find out what a wet signature is. So our legislation now, after we hope that this is passed today, will allow for documents to be filed with electronic signature or with a wet signature. So we have the option now. And the registry will be allowed to accept documents signed in either way. Section 4 of the ordinance, we are proposing by this legislation to amend by deleting subsection 8 in its entirety and replacing it with new provisions. The proposed amendment allows for electronic filing of documents at the registry. So not only are we moving to electronic signatures, we are also now moving to electronic filing at the registry. The existing provisions allow for the filing of physical documents at the registry, and this new option will allow for greater ease and convenience for both the registry staff and for service providers. The requirements for the documents filed electronically to be endorsed as filed still remains. What is important with this amendment is the fact that the date of receipt of payment for the document will be the proof of the actual filing of that document. I want service providers to hear me now. Filing without payment would not guarantee proof that the document has been filed. So the payment is important, and we could understand that because the government needs the revenue. The document filed would only be effective and valid as of the filing date noted on it. We are doing, therefore, two things, Madam President. We are modernizing in terms of the electronic signature now being permitted, and we are modernizing further by allowing documents to be filed electronically. What that does is that it enhances our ease of doing business. And I believe that that is important if we're going to build out the sector, that persons dealing with Nevis, choosing Nevis to invest and to have their financial services handled in Nevis, that we make it as easy and as seamless as possible for them to do business. I believe that this sector has long been asking for these types of initiatives, and we have come today to seek to amend accordingly. A new subsection 12 has been added to section 8, which allows for filing of documents which contain an electronic signature. Where an electronic signature is included on any document submitted for filing, the provision mandates the acceptance of that document by the registrar. Mandates is important because it means, therefore, that the registrar now can't refuse to accept because it's an electronic signature. So we have taken that step forward. And as I said, we have not sought to exclude those persons who prefer to do things the old-fashioned way. And so we are accepting electronic signatures and wet signatures in order to file documents. Section 9 of the ordinance, Madam President, has been amended by deleting the entire existing section, as that section previously dealt with notice to holders of bearer shares. In fact, I will come back to that theme time and time again, because what the drafters of the bill currently before the House have done is to seek, Madam President, wherever bearer shares were mentioned or dealt with under the ordinance, to delete and repeal those provisions and to put new provisions which reflect the new thinking by the government in relation to bearer shares. So section 9, which hitherto talked about notice to holders of bearer shares, that section has been removed in its entirety. The proposed amendment now imposes a general requirement in relation to notices which are to be provided to shareholders, except as it relates to notices regarding meetings of shareholders. All notices that relate to meetings of shareholders are addressed by the existing provisions of Section 85 of the ordinance. That section, Section 85, is specific to the procedure for the provision of notices to shareholders as it relates to meetings. The new amendment under Section 9 outlines the procedure to be followed for giving any other type of notice or information to shareholders. If I can move on quickly, Madam President, we have proposed an amendment to Section 18 of the ordinance. The proposed amendment under Section 18 seeks to delete the existing subsection 4 and to replace it with a new provision relating to the service of documents on a corporation. Now, this is very important. The existing subsection 4 allows for service of process of documents on the registrar in circumstances where a corporation fails to maintain a registered agent, or where said registered agent cannot with reasonable diligence be found at their physical place of business. So what used to happen is that when a corporation was sued, or there was a need to serve some document on that corporation, and the corporation failed to maintain a registered agent on the island, or the registered agent cannot be found, then by default, the registrar was served. Now that created a tremendous burden on the registry, Madam President, because whenever documents, lawsuits, etc. were filed on the registrar then had to maintain those files at the registry. So you had storage requirements, you had other requirements that were imposed, that the registry now had responsibility for the safe storage, as they had become the repository, if you will, of these documents. And so the registrar has complained and said, well, this is an onerous imposition. And so we have responded to remove the requirement so that there is no longer any need to serve the registrar, and service of process in the circumstances where the registered agent of any corporation cannot be located will be effected at the last known registered office of the corporation. That is the provision. We'll have to see how it works. But that is the intention, because we could not continue the position of the registrar being the recipient of last resort, if you will, of process. And so documents now and service of process will be on the last known address. This will remove the onerous obligation on the registrar and the registry staff to accept as well as store documents in legal actions which were served on the office as agent on behalf of a corporation. Now let me be clear, I'm talking about lawsuits that have nothing to do with the registry or the registrar. Party A decides to sue Company B. Company B has not maintained a registered agent, and so the old provision was that they would serve the registrar. And the registrar then would have responsibility of storing those documents, perhaps even trying to locate the Company B. Company B may have decided that they're no longer interested in being registered here. We are saying that we are now removing that cup from the registrar, no longer their responsibility. Further to the amendment of subsection 4, we will delete the existing subsections 5, 6, 7, and 8 under section 18. Those provisions explain the procedure to be followed in the event that documents were served on the registrar. And since we are no longer permitting service on the registrar, there is no need for those provisions. And we've accordingly renumbered, Madam President, the other provisions under section 18. We move to section 24. And under that section, we have amended subsection 1, paragraph J, to remove the reference to bearer shares. Again, a consistent theme throughout. And this is entirely appropriate in keeping with the other amendments to the bill that are being proposed. We've also made amendments to paragraph K and subparagraphs 1 and 2 by deleting those subparagraphs, which again make reference to bearer shares. They are no longer applicable. At section 32 of the ordinance, we've amended by deleting subsection 4 in its entirety and renumbering subsection 5 as a new subsection 4. That subsection references bearer shares and the applicable provisions of section 24, which were already proposed for amendment. Thus, the provision is no longer applicable and has been removed. We are throughout going to be engaged in some renumbering, Madam President, as we remove some sections. Section 41 was amended to remove a reference to bearer shares contained at subsection 2 thereof, and the new provision speaks only to registered shares which a corporation is authorized to issue. Subsection 3 references certificate to be issued for a bearer shareholder in accordance with the provisions under subsection 2. Having removed the reference to bearer shares, naturally, there is no longer any need for that provision. Section 48, we have amended in subsection 3 by deleting the entire subsection, which made reference to the issue of bearer shares and registered shares by a corporation. The amendment now makes it clear that a corporation is only authorized to issue shares in registered form. Subsections 9, 10, and 11 under section 48 were also deleted, as the references in those provisions to bearer shares or shares in bearer form are no longer applicable. Under the new subsection 10, the words "if a registered share" were also deleted, as this is no longer applicable, as the amendment now only allows for shares to be issued in registered form. And in the new subsection 10, paragraph C, that paragraph was deleted in its entirety, as a reference to bearer shares is no longer applicable. Section 55 was amended in subsection 2 by deleting that subsection in its entirety, as it contained references to bearer shares and therefore is no longer applicable. Section 60 of the ordinance, Madam President, was amended in subsection 2, paragraph F, by deleting the words "unless the charge is a security for bearer" as they appear in that paragraph. This amendment follows on from the other amendments which relate to the removal of references to bearer shares. Section 85 was amended in subsection 4 by deleting that subsection in its entirety, That subsection made provision for giving of notices for meetings to bearer shareholders. Again, no longer applicable. Section 93 was amended in subsection 1 by deleting the reference to and of holders of bearer shares as they appear in that subsection. Again, no longer applicable. Section 94 of the ordinance was amended, or is to be amended, I ought to say, in subsection 1 by deleting the reference to and every holder of bearer shares as they appear in that section. Again, no longer applicable. Subsection 8 was deleted in its entirety as it made provisions for voting in relation to bearer shares. If we're no longer going to have bearer shares, those provisions are no longer applicable. We have gone further and amended Section 101, and Section 101 was amended by deleting the existing heading, Requirements for Keeping Books and Records and Register of Shareholders, and replacing that heading with Documents to be Kept by the Corporation. This new heading more accurately reflects the requirements under the new provisions of that section. We have deleted subsection 1 of Section 101 in its entirety, as that provision contained requirements for keeping of certain documents by a corporation, and the new subsection 1 creates an itemized list of specific documents that are required to be kept by a corporation, which include, Madam President, but is not limited to, the Articles of Incorporation, the Register of Shareholders, Register of Directors, minutes of meetings, and notices. There's also a new requirement for the corporation to provide copies of any such documents to the corporation's registered agent for said registered agent to maintain at its office. Why is that important? It's part of the regulatory function, Madam President, so that whenever the regulators make their site visits, for example, and go to the registered agent's office and say we would like to see the records for Brand Limited, that the registered agent is now being mandated to have copies of the relevant documents. In the past, what used to happen is that companies would maintain a registered agent here, but naturally all of the activities would be elsewhere, including their management, their meetings. And registered agents here would simply be an office where no documentation was kept. Well, we are living in a new world, and we are responding to the changes that the regulatory environment imposes. And there is now a requirement that documents are to be kept by the corporation, but also copies to be maintained with the registered agent locally. Subsection 2 of Section 101 was deleted, as the requirements under that subsection were incorporated in new subsection 1, which speaks to the maintenance of the register of shareholders. Subsection 2 was replaced with a new provision which imposes an obligation on the corporation to notify the registered agent of any change to its register of shareholders or directors within 15 days of the date when that change was made. Again, very important for regulatory purposes. So, for the company registered here in Charlestown, with a registered agent in Charlestown, but doing its business in South Africa, having directors and shareholders all across the world, we're simply saying that when changes are made to your directors or shareholders, you have 15 days in which you must notify your local registered agent. And that, again, is our response to the new regulatory environment that exists internationally. The new provision also imposes an obligation on the corporation to provide a registered agent with written information regarding the physical address at which the original register of shareholders and directors are held. So we are saying, even though there is no requirement that the shareholders register and the register of directors is maintained here in Charlestown with the registered agent, that we are now saying that the registered agent must know where those registers are being maintained. And so if it is number 2, whatever street, in Munich, in Germany, then the registered agent must know where the registers are being maintained, and that obligation is now being imposed on the company. Subsection 3 of 101 was deleted and replaced with new subsection 3. And under the new subsection, the corporation is required to give notice of any change of that physical address at which the register of shareholders and directors are kept, and again, that should be done within 15 days. So they must give notice of changes of shareholders and directors within 15 days to the registered agent. They must give notice of change of where the register of directors and shareholders are being maintained to the registered agent, and all within 14 days of any changes that are made. We have added a new subsection 5 to section 101. This new subsection provides for the maintenance of all documents required to be kept under that section, and that they must be maintained by the registered agent for 6 years. Madam President, this is very important, that the legislation is specifically the period of time for which documents must be maintained by the registered agent. 6 years after the date on which the corporation is dissolved or otherwise ceases to exist. So if the corporation ceases to exist today, 24th August, there is now a legal statutory obligation on the registered agent to maintain the records for that corporation for a period of 6 years from today. That brings some legal certainty. It also allows the industry to understand that after that period has elapsed, they are then within their legal right to dispose of such documents. And so that period has been fixed at 6 years. This allows for information to be available to those who may require and request it, even after the corporation is no longer operating. But it is not open-ended. The period is 6 years. So if you were to come 7 years, 12 years, 20 years after a corporation has been dissolved or no longer exists, then there is no obligation on the part of the registered agent to maintain records for any period beyond this 6-year period that has been set by law. We have amended section 102. The existing section 102 addressed the issue of bearer shares and related provisions in that regard. In keeping with the amendments to remove all references to bearer shares, the entire section 102 was deleted and replaced. The new heading for section 102 is Prohibition against bearer shares. I hark back to where I started, Madam President. I sought to outline the evolution that in 1984 we had bearer shares. We later thought it best to continue with bearer shares, but to immobilize them with an authorized custodian. We have now gone to the next level now and are prohibiting bearer shares. And so when I looked at the amendments, I looked at the provisions of the bill being debated, Nevis Business Corporation Amendment Bill 2023. I wondered to myself, Madam President, so what would happen to those companies that already have bearer shares? Because we're going into the House on the 24th of August to say that we will no longer allow bearer shares. So if Brand Limited already has bearer shares, what happens to them? And I'm so happy that I didn't have to call anybody because the drafters understood the assignment. And so they have now, in the new section 102, prohibition against bearer shares, where we expressly prohibit the issuance of bearer shares by any corporation after coming into force of this ordinance. The new subsection 1 provides that a corporation shall not issue bearer shares or convert any registered shares to bearer shares or exchange any registered shares for bearer shares. Put differently, Nevis is out of the bearer share business. The new subsection 2 takes into account a specific grace period to be allowed for the conversion of existing issued, converted, or exchanged bearer shares to registered shares. And so the drafters answered my concern by saying, if Brand Limited had bearer shares, then we're going to give Brand Limited a grace period to convert those bearer shares to registered shares. And that period that has been given, Madam President, is 6 months. So we've said 6 months from the coming into force of this ordinance, that is the Nevis Business Corporation Amendment Bill 2023, that 6 months after the date of that coming into force, those who are holding bearer shares will have an obligation to have those bearer shares converted to registered shares in compliance with Nevis law. In the event that conditions under subsection 2 are not complied with within 6-month period allowed, then the amendment provides in subsection 3 for the automatic conversion of any issued or converted or exchanged registered bearer shares, to registered shares. This automatic conversion is only applicable after the expiration of 6 months. So how this is intended to work is that we are hopeful that the service providers are paying attention, and we will, of course, be sending out to them the new law. I'm, of course, assuming the law will get the support of the House, and we can pass it today. Now, the new law is saying that for those corporations that have bearer shares, that since Nevis is now out of the bearer share business, and we're no longer allowing bearer shares, that we are given a grace period of 6 months for those bearer shares to be converted to registered form. And we are saying that if you do not do so, then there will be an automatic conversion of those shares after that 6 months has expired. So you have 6 months within which to act, after which the law is saying that bearer shares, will be automatically converted to registered form. The drafters have gone further to say in subsection 4 that bylaws of the corporation shall be deemed to be amended from the effective date to provide that the corporation is not authorized to issue bearer shares. Subsection 5 of the new section 102 places an obligation on the authorized custodian of bearer shares to surrender the bearer shares to the corporation within 3 months of the effective date. And so, while we are no longer going to have the custodian, authorized custodian, we are saying to those out there who had been hitherto authorized as custodians to hold bearer shares, that once we pass this legislation today, they have 3 months within which to surrender those bearer shares to the company. So again, my example of Brand Limited, that whoever the custodian of the bearer shares in Brand Limited might be, that custodian would have 3 months to surrender those bearer shares to Brand Limited. And Brand Limited, in turn, under 102, Section 102, will have an obligation within 6 months to convert those bearer shares to registered form. And if they don't do it, then the law suggests that it should be done automatically. The authorized custodian is also required to give notice of such surrender of the bearer shares to the registered agent. So, Brand Limited has authorized bearer shares out there, forgive me. The custodian holding those bearer shares has 3 months to surrender them to Brand Limited, and that custodian must also give notice to the registered agent of Brand Limited that it has surrendered the bearer shares. At the time of the surrender of the bearer shares by that custodian, the custodian shall also submit a written statement to the registered agent and the corporation providing certain information relating to the bearer shares, including the full name of the beneficial holder of the bearer shares. And one can understand the wisdom behind that, Madam President, because that is the mechanism then which allows the conversion. Because once the custodian says, I was holding 1,000 bearer shares in Brand Limited for the owner, Mark Brantley, then it allows the company to then register those shares in the name of Mark Brantley within the period allowed under the law. And so we can understand how the sections are working together harmoniously to usher in this new era of no bearer shares being permitted in Nevis. The new subsection 7 provides for the retention of records containing bearer share information by the registered agent for a period of 5 years from the effective date of the amendment to the ordinance. The new subsection 8 imposes a penalty of up to $10,000 for contravention of the provisions of subsections 5 and 6 of section 102. And that's important, that again, registered agents, service providers, that they are in touch with their clients, they're informing their clients what is happening, and they alert their clients of the penalties that can accrue. I want to make it clear, Madam President, that the government is not in the business of penalizing people. We're in the business of doing business. And we would much prefer for our service providers and those corporations registered here, those entities registered here, to remain in compliance with the law. Sometimes the service providers complain and say that the fines and the penalties are too onerous. And my response to them is, there's actually no fine and no penalty if you do what you're supposed to do. They only become applicable when people fail to comply with the law. And so the penalty of up to $10,000 is a significant penalty, but it is entirely avoidable if the service providers and the companies simply conform with the requirements according to law. We have lastly amended section 142 of the principal ordinance by deleting that section in its entirety and replacing it with new provisions. Under the existing provision, the applicable penalty was a general penalty for contravention of one or more of the provisions of the ordinance for which no specific penalty is applicable. This allowed for the imposition of a fine of up to a maximum of $10,000. The section is now being amended, Madam President, to include subsection 1, which imposes a penalty of up to $10,000 on a corporation found in contravention of any of the provisions for which no specific penalty is applicable. A new subsection 2 was also included to impose a penalty of up to $10,000 on an individual found in contravention of any of the provisions of the ordinance for which no specific penalty is applicable. The amendment under section 142 seeks to make distinction between the applicable penalties for a corporation and an individual found in contravention of the ordinance. So basically we are seeking to specify who is subject to that penalty. Madam President, I have sought to go through the explanatory memorandum, by pointing out how the various sections of the principal ordinance will be impacted by this, the Nevis Business Corporation Amendment Bill 2023. And I hope that by taking the approach that I've taken, the House and the public has an appreciation of what it is we are seeking to do by this new legislation, to modernize, to assist in tightening up our regulatory environment, to finally outlaw bearer shares, and to ensure that through our electronic signature and electronic filing, that we provide greater clarity and greater ease of doing business for the island of Nevis. May it please you, Madam President.